We do not win lawsuits. State governments lose. The only time we allegedly win a lawsuit, it is in reality the federal government winning out over the sovereign rights of a state. Once again, the American Indians are the pawn.
It's officially June, which means we're going to be flooded with a series of critical Supreme Court decisions. But there's one decision that will impact 574 distinct and sovereign nations.
UNFTR.
In the brief and brutal history of the United States, tens of thousands of Native children were stolen from their parents in tribal communities and forced into labor camps and residential schools, stripped of their humanity, identity, and often their lives. Those who survived and returned found themselves devoid of any culture or heritage, any connection to their ancestry and families. Some started over. Others left tribal territories and assimilated into white culture. None escaped the generational trauma. In 1978, Congress attempted to rectify this practice with the passage of the Indian Child Welfare Act, referred to commonly as ICWA. Among the provisions are strict guidelines for adopting Native children. There are accounts of residential schools, by the way, operating into the 1990s by Christian groups, but the formal practice ostensibly ended in 1978 with ICWA. Today, the act is being challenged by combined court cases jointly referred to as Brackeen v. Haaland. The case was argued in front of the court in November of last year and involves Native children and their white adopted family in Texas. And this is a tricky case, and we'll get into the particulars, but there's one thing to bear in mind at the beginning, and that's the children. The Brackeens are a successful family with 2 biological children of their own living in Texas. In what they saw as God's will, they decided to become foster parents. That's when Zach, not his first name, entered their lives. While fostering Zach, the Bureau of Indian Affairs, or BIA, discovered that relatives in Navajo territory were willing to serve as adopted parents. And that's where the trouble began. Zach's biological parents struggled with addiction. It's why Zach wound up in the system to begin with. After being fostered by the Brackeens, matters were further complicated when Zach's mother had another child, this time a baby girl. The Brackeens moved to foster Zach's half-sister in the interest of keeping family together as their case to fully adopt Zach went through the courts. The lower courts in Texas found that in attempting to remove Zach from the Brackeens' home, the BIA was violating equal protection standards under the Constitution, and that the agency wasn't acting in the best interest of the child, thereby challenging both the federal law and the manner in which it's applied at the state level. Through multiple challenges, the adoption has held thus far, and the Brackeens are fighting to retain that right and apply it to Zach's sister. Of course, given the length of time that this has gone on, Zach was placed in 2016 when he was only 10 months old, it certainly adds an emotional element, as this is the only family that Zach and his sister have ostensibly known. There was a twist, however, in the Texas family court ruling that gave the Brackeens primary custody with the stipulation that he visit his extended Navajo family for periods during the summers. So Zach's Navajo family aren't an unknown quantity. And technically, given the way ICWA was written, he should have been sent to live there years ago. Now, all of this is up in the air as the Brackeens and Zach's blood relatives wait anxiously for the SCOTUS decision. And as complex as this individual situation seems, it's even dicier when you understand what's at stake and the real motives of those who are funding the Brackeens' case. The Brackeens, like many other foster and adoptive parents, had become attached to Zach and his sister and sought legal counsel to determine if there was any way to keep them. They'd fallen in love. But federal law is extremely clear that in adoption cases involving a Native child, all efforts must be exhausted to place the child with Native families. There are essentially 3 avenues to consider in the Native adoption process as set forth by ICWA. The avenues are termed preference under ICWA, which stipulates, quote, "A preference shall be given in the absence of good cause to the contrary to a placement with one a member of the child's extended family, 2, other members of the Indian child's tribe, or 3, other Indian families, end quote. So it's important to understand both the intent here and the specificity of these preferences. Family and extended family first, members of their tribe second, and if neither is possible, another native family may pursue adoption regardless of geography or whether the child is even considered part of the petitioning tribe. In all ways, the law was designed to keep native children with native families. Remember, what Congress was trying to overcome was the centuries-old practice of stripping native children from their ancestral roots and placing them within white society. Left to their own devices, even after the brutal residential schools were closed, state adoption agencies almost always took native children away from tribes, perhaps believing they were acting in the best interest of the child. And in fact, the concept of best interest is one of the hinge points of this case. So what we've seen in the multiple challenges through the courts regarding the Brackeen case is multifaceted. Zach's biological parents were drug users, therefore he was placed in foster care in his best interest. Having formed a bond with the Brackeens and their other children, and the fact that they were successful, loving, and stable, they made the argument that they were clearly in Zach's best interest. But their claim goes even further than challenging the best interest concept by claiming that placing native children with native families, whether related or not, violates the Equal Protection Clause of the Constitution based on racial grounds. Now let's introduce the bad actor representing the unspoken part of this challenge. From the New York Times, quote, in 2015, the Goldwater Institute, a conservative think tank in Arizona with donors who have ties to the Koch brothers, put the law on its roster of targets. Goldwater argued in about a dozen cases that the act violated the equal protection rights of Indian children because it was more difficult to permanently remove them from abusive homes, end quote. Curious, right? What's a conservative think tank's interest in the adoption policies of native children in the United States? Interestingly enough, this isn't Goldwater's first go-around. In fact, they've been funding challenges to ICWA for more than a decade. This is just the furthest that they've come. A 2017 article in The Nation provides clues, if not the outright answer, to this puzzling question. Quote, Goldwater's stated goal is to have the U.S. Supreme Court strike down ICWA as unconstitutional. The implications go far beyond child welfare. Many tribal members fear that if Goldwater is successful, it could undermine the legal scaffolding of Native American self-determination, end quote. And there it is. The child welfare aspect of the challenge is likely subterfuge for the greater goal, to which the Brackeens are just a matter of convenience. And that goal is to attack the very underpinning of tribal sovereignty and Congress's exclusive and constitutional right to manage all nation-to-nation affairs with sovereign tribal governments. And why would that matter? Well, as the Nation article continues, quote, a ruling in Goldwater's favor, according to legal experts, could undermine the authority of tribal courts, shutter tribal casinos, and open up reservations to privatization, something that could benefit oil and gas developers like the Koch brothers, end quote. Outside of attacking tribal sovereignty, Goldwater typically focuses on the usual slew of libertarian policies like school choice and voucher systems to attack the public school system, loosening environmental standards for corporations, promoting electronic cigarette sales to minors, and dismantling unions. Apart from these large and coordinated efforts among conservative and libertarian think tanks, which we've covered exhaustively in the past, attacking native sovereignty was a little bit of a side hustle. But with the new conservative supermajority on the Supreme Court, they've hit the big time, and they're close to reaching a dangerous milestone. The reason the Nation article can make such a leap from child welfare to a more insidious claim of large-scale land grabs is that the Koch family fortune itself has roots in stealing natural resources from tribal lands. There's also the matter of gaming, which in many states remains a carve-out for native tribes under an interpretation of commerce rules. The biggest encroachment to sovereignty, where commerce is concerned, is the constitutional protection of trade relations that places commercial transactions referred to as intercourse between sovereign nations under the strict purview of Congress. If the Brackeen case exposes an opening in this relationship and calls congressional oversight into question, it opens a Pandora's box of other states' rights claims to determine their own relationship with sovereign native nations. Let's unpack the legal arguments of the case, beginning with the biggest issue that always faces the SCOTUS, and that's the issue of constitutionality. On this point, it brings us back to the concept of sovereignty. It's the central idea that has to be understood when contemplating legal and political matters on and off tribal land. In the simplest of terms, each of the 574 federally recognized tribal territories are viewed as sovereign and independent nations. Any, quote, intercourse between nations is detailed in treaties and federally recognized agreements and statutes. Straightforward enough. Where things get complicated is that the United States government maintains several obligations to these tribal entities that are different from so-called normal nation-to-nation relationships with other countries. U.S. relations to tribal governments are referred to as sui generis, a Latin phrase that technically means in a class by itself. But at the root of the concept, any negotiations between the United States and tribal nations are under the authority of Congress because it relates to congressional use of foreign powers. When it comes to commercial interests, these powers are referred to as plenary powers. Under the Commerce Clause of the Constitution, plenary powers determine interstate and intergovernmental rules of commerce, and no state is allowed to enter into separate agreements without the express consent of Congress. In an amicus brief filed on behalf of the tribes in the Brackeen case, the ACLU argues, quote, "The Indian Child Welfare Act is constitutional and urges the Supreme Court to uphold the centuries-long legal precedent upholding tribal sovereignty, including tribes' rights and ability to preserve their unique cultural identities, raise their own children, and govern themselves," end quote. Here's Justice Jackson pressing the attorney for the plaintiff on the concept of plenary power and constitutional provision that grants jurisdiction exclusively to Congress.
You have seemed to be very upset about Congress's exercise of plenary authority over Indian affairs. You say we need to look at it in a more narrow lens, I guess consistent with the sort of general understanding that Congress has limited authority. What I'm a little bit confused about and concerned about is whether it's really correct that we have to look at it so narrowly, that is the scope of Congress's authority as it concerns Indian affairs, when we have said over and over again that Congress has plenary and exclusive authority, and when the history of our Constitution indicates that the constitutional design was about ensuring, in a way, that the federal government had the authority over the tribal relations, tribal affairs, and not the states. It seemed to me that baked in to the Constitution's structure related to this, outside of just the Indian Commerce Clause provision, is the notion that the federal government vis-a-vis the states was going to be taking charge of this, especially in light of the Articles of Confederation precedent. So if that's the case, then what would you say about the thought that rather than, searching for, what additional limits there are on Congress's authority, we start with the premise that with respect to Indian affairs, Congress has plenary authority, and therefore, as we've said in all of these prior cases, as long as it involves Indian affairs, and Congress is making policy judgments, they have a constitutional basis for doing so.
The attorney essentially responds by affirming the nation-to-nation relationship, but contends that it relates more to land and commerce, and that Native children are neither. And therefore, the tribes themselves have no proprietary interests in the matters of adoption. But where human interactions are concerned outside of land, commerce, and treaties, the attorneys representing tribal interests had other precedents to stand on, such as the 1974 ruling in Morton v. Moncari that examined whether preference to natives in hiring at the BIA was discriminatory based upon race. In this instance, the court ruled that as a federal agency that oversees the relationship between sovereign entities, it is also sui generis. From the ruling, quote, "The preference, as applied, is granted to Indians not as a discrete racial group, but rather as members of quasi-sovereign tribal entities whose lives and activities are governed by the BIA in a unique fashion," end quote. Moncari and other cases essentially affirm the notion that each tribal territory is indeed sovereign, and that their special nature, as opposed to, let's say, France or Japan, carries special consideration. Justice Gorsuch, considered the most knowledgeable on tribal affairs and a staunch advocate for sovereign rights, invoked Moncari directly and firmly in his questioning, intimating that the plenary powers of Congress were absolute in all matters relating to Native people on and off tribal land. Justices Sotomayor and Kagan followed similar lines of questioning, and even Justice Barrett seemed reluctant to concede any ground on the plaintiff's states' rights arguments. But the attorneys, clearly prepared for this, made greater headway with Kavanaugh, Thomas, Alito, and Roberts with the best interests of the child argument, and contending that the particular carve-out for adoption on what they called racial grounds was a bigger constitutional issue with respect to the Equal Protection Clause. Where the conservative justices, with the exception of Gorsuch, all got hung up was in the third preference for adoption. Not parents or extended family or even tribal members, but tribal rights universally. As it stands, ICWA basically states that a Native child is better served living with other Native people, even if they're of no blood relation, than any non-Native family. More than likely, that's where the decision will hinge, as you can hear in Chief Justice Roberts' questioning.
I have, as I mentioned to Mr. McGill, difficulty understanding how the placement priorities work. So maybe I'll try an example. Let's say there's a 6-month-old baby that had been born to an Indian couple, and the Indian couple, for whatever reason, is no longer there, and there are also no extended family members in the tribe. A non-Indian couple comes forward and says, we would like to adopt the 6-month-old baby, and they check all the boxes of their best interest of the child. In other words, in normal circumstances, this would be a perfect placement for the child. But non-family members of the tribe say that no, they think it would be better for the child to be raised with the tribe on the reservation. Does that priority trump the other best interests finding?
But several briefs filed in support of the tribes refute the best interest claim, noting that Native children who remain in tribal areas have had more positive psychological outcomes. Indian Country Today, a Native publication, writes, quote, "At its core, the law is simple," Chairman of the Oneida Nation Tahasi Hill said in a press conference last month. He noted that the American Academy of Pediatrics and the American Medical Association are among the many groups that filed amicus briefs with the Supreme Court recommending the upholding of ICWA and warning of the harm that the loss of ICWA would bring. He called the law wildly successful. Tribes, child welfare experts, and medical experts, those who know the law and the needs of the children best, overwhelmingly oppose the efforts to overturn ICWA, end quote. This best interests argument supports the critical distinction made by tribal attorneys and repeated by the liberal justices on the court, that in all ways dealing with Native people, they must be viewed as political decisions, not racial. Race is just a construct made up by white people. These are political relationships. That's incredibly important. Think of it this way. A child from Germany, Ethiopia, or Japan, pick a country, any country, has a willing adoptive family from both the United States and their home country. Both are able to care for them, both capable of providing a home, education, love, support, whatever the child needs. Would that child thrive more in their native country or somewhere else? Now, most people that aren't evangelical Christians would likely understand the obvious answer is their native country. That's what the third preference refers to. But this line of reasoning appeared to be a bridge too far, well into the oral arguments, with justices like Brett Kavanaugh, who struggled with the classifications between political and racial. Here's Kavanaugh.
And then you suggested that everything's been operating smoothly. We leave well enough alone, but I just want you to speak to the concern on the other side, which is, you come in as an adoptive couple, you want to adopt a child. The state court otherwise would say the best interest of the child would be to go with you. And then you're told, no, you're the wrong race.
The SCOTUS has a few paths forward. It can uphold the whole thing. It can break it apart and create new standards for when children are placed into foster care. Most terrifyingly, it could just strike ICWA down in its entirety, which would place state authorities at the center of the adoption process, just like it was prior to 1978, when the vast majority of Native children were placed in foster care off tribal land, even when parents and extended families are an option. My hunch is that the likelihood that ICWA survives in its entirety is unlikely. And I would be horrified and honestly a bit surprised if a slim majority struck it down in its entirety. My guess is that it lands somewhere in the middle. A disastrous decision regardless that contains narrow language related to adoption proceedings that reverts to a situation much like we had prior to ICWA, but with provisions that attempt to safeguard precedents that uphold the notion of sovereignty where commerce and law enforcement are concerned. So from the line of questioning, my guess is that Gorsuch will align with the liberal justices in attempting at least to uphold ICWA. It also seems that Alito, Thomas, and Kavanaugh are just prepared to light a match to sovereignty altogether. Now, ironically, I think Barrett is kind of a wild card. She appears to get the idea of plenary powers, but struggles with the specific nature of adoption, which would certainly track given her experience as an adopted parent and an evangelical. She's the biggest reason in my mind that this might wind up somewhere in the middle. But if we assume the two extremes, ICWA struck down or entirely preserved, I think it's fair to say that Gorsuch, Jackson, Sotomayor, and Kagan will side with preserving it. Kavanaugh, Alito, Thomas, and Barrett light a match, and that leaves Roberts. And that's why I highlighted the clip of him pressing the attorneys for the tribes on the idea of best interest when it comes to situations that do not involve family or extended family, and that makes me very nervous. But here's another thing that I find so disheartening and even a little sickening, no matter the outcome. The Brackeens might be lovely people, but they're also evangelical Christians. They're part of the legacy of the fundamentalist ideology that views Christian primacy in the matters of family. The same legacy that governed the administration of residential schools that stole tens of thousands of Native children under the absolution of Christ and murdered tens of thousands in the process. The unholy alliance of zealotry with forces like the Goldwater think tank make this all the more disgusting. If ICWA is struck down or even just dismantled, it will be yet another evil libertarian Christian fundamentalist victory through the courts. Another in a long line of victories in their relentless campaign to turn back the hands of progress and suppress the rights of Native people, or any non-white Christian rich people for that matter. Here endeth the lesson, and here's hoping for some positive outcome.